The governor is a postman only. Nothing more than that. He does not have any more power than a postman does. In Tamil Nadu, we find a new game because the BJP has now chosen Tamil Nadu, like they have chosen Kerala, and their experimentary laboratory is Karnataka. The government, in order to survive themselves, required police, and in turn, they shield all the police officers so that they could have a false security for them to continue. It is only the united voice of the people which can stop this bulldozer democracy.
Hello everyone, I'm Dhanya Rajendran. Today I'm in conversation with Justice K Chandru. He was a former judge of the Madras High Court, a man who has the reputation of disposing of 96,000 cases as a judge. I will be speaking to Justice Chandru on a wide range of things, from custodial torture to what is the role of a governor and where does he see India's democracy and judiciary at this point. Before I go into the interview, a reminder to all of you, do become a member of the News Minute and do subscribe to our YouTube channel. Justice Chandru, thank you very much for joining me. My first question to you is, last week we saw the death of a young man in Chennai. His name is Vignesh. He was arrested by the police. The next day he died. The police said that he had injuries previous to arrest, but we have enough evidence and suspicion now that it is a custodial death. Why does this keep happening? Why do police behave with such impunity, especially in a state like Tamil Nadu, where we saw so much outrage after the Satankulam deaths?
There is always a claim that the Tamil Nadu police is equal to Scotland Yard. I don't know how that comparison came. They were always claiming they were very efficient, but then they never gave up this encounter as one of the method of crime detection. Now, in that process, what is really happening, even when the Jai Bhim film came, many people ask me, will this will stop because of this? I will said it will never stop because only on the increase. In fact, as a lawyer, I would have fought some 15 encounter death cases, but as a judge, I would have heard some 45 cases. Therefore, the amount of encounter killing is on the increase, and the word encounter is now a common word even among the slum people, lower middle class people. Even when they come and tell you, they say, sir, so and so is going to be encountered. Now, there is no secret also, because in many cases, some of the local magazines have reported that X is going to be killed, and the next day or in 2 days they were killed. Even recently in Kanyakumari, an incident of saying a dreaded criminal was killed. There are two reasons for that. One, the investigation technique or skill of the police at the lower level is very poor and barbaric and very century old. In fact, the police force itself was raised only to maintain law and order. The crime detection came much later, and they were using several methods. And there are known torture methods which are adopted even today, and there are at least 70 of them have been listed of different torture. The main reason is twofold. One, the justice administration system is a failure today because you don't get justice immediately, and the people who are affected are impatient and people want quick. In fact, recently somebody said, even the Supreme Court judge said, are you asking for instant noodles or an instant coffee and things like that? People want instant solution. The judiciary says you go by the procedure, but then how long to wait? There's one question. When there is instant solution, the people who do encounter become heroes among the people. So the acceptability of instant punishment is welcome. We saw in Hyderabad, the officer was garlanded, laddus were distributed and things like that. So therefore, basically the system is completely eroded. The basic values or the basic system. The policemen who do this kind of method to extract confession, extract admissions, or finish off people to get good name and things like that in the area of there is a crime detection. They are also of the indirect or implied assurance that no action will be taken against them. I am yet to see cases where the department itself took action against them. Some time ago, the Human Rights Commission said encounter of the maximum can be only a best defense. That has to be proved only in a trial. And in case of an encounter death, the policeman will have to be charge sheeted for murder. And as a defense, they can say they only to defend themselves this has happened. But all these guidelines have never been followed. It's only in cases where the court were monitoring cases, SIT were appointed, or special investigation is done, there those cases policemen have received appropriate punishment. Even there, it takes long time for such judgment. You saw the a black was in America. Floyd was killed. The entire trial in this trial court, the appellate court, the state Supreme Court, and even the US Supreme Court, the case is all over in 2 years. And the guilty policemen are all inside the jail. Now, such a thing doesn't happen in our country, and therefore the impatience of people lead to a implied welcome to this kind of measures. And I think there should be a basic attitudinal change to this problem, and court also must do its duty of deciding this matter faster so that people don't look for instant solutions.
So, as you said, there is definitely a problem here. There is less conviction, policemen are never taken to task, and violence is celebrated. But what really is the solution, sir? Recently, my colleague Sarita Balan looked at 5 cases of custodial murders in Kerala, and not one police officer has been taken to task properly. Some of them were suspended for a few days or kept on probation, but they were all brought back. They were transferred out, but they were brought back, and some even got promotions. So, what is the solution? Is it police reforms? Is it political will? Or is it to make sure that these policemen get punished? Or is it a combination of all this?
Now, the question is not very simple. They requires a simple answer, but then there are three things. There are enough police reform reports, but the government, successive governments are hesitant to implement those reports for two reasons. The government, in order to survive themselves, require police, and in turn, they shield all the police officers so that they could have a false security for them to continue in order to teach a lesson against the political opponent. The such a armed police is required for them. This is one reason. Secondly, that a combined effort of investigation, trial, and an appellate system, the administration of justice, as a requires a overhauling. That is, people should think that everybody is a partner in unraveling the crime and punishing appropriately, and that doesn't happen at all. Each has got an inbuilt delay. Now, if there is an incident, there is enough demand from the human rights group, from the opposition leaders, and people who are concerned, and then the agency is changed for investigation. Now, except in Satankulam, where the father and son killing led to an international outburst, the news was such a widely spread because they are also a very powerful group in that area, and therefore there is more attention. So quickly the government handed over to CBI. The High Court ceased of the monitoring process and fixed a deadline till November for pronouncing orders, and the trial is going on in a expected speed, and therefore there is little amount of satisfaction for the people in respect of that incident because appropriate people at the appropriate time took decisions to correct the error. But what is required is a long-term correction that when the advanced technology is introduced in the crime detection, now there are many, for example, CCTV. Everywhere they have set up CCTV. There is not a place where there is no CCTV. So quickly they were able to identify the culprits, and there is a doctor who was killed, and within a few minutes the policemen were able to arrest 2 lawyers. It is the lawyers who are preventing the arrest, claiming some so-called immunity, and they were even after the blood of the inspector who went to arrest him. Then the High Court took a very wrong stand of pulling up the officer and asking for apology. Therefore, every force which is intended to help this system work for cross purposes, and there are pressure group which takes advantage of this delay, and therefore the delay helps the accused, and it brings a frustration to the victim and their supporters. Therefore, I think we need to have a full overhauling on the system. A more increased technology could be an answer. Secondly, the police station, which is supposed to be manned or supervised by a civil administration. Now, there is a revenue control over police. It is the district collector who keeps track of the police movement. They can take action, they can recommend action. Under 145 of the police standing order, it is the revenue who recommends action against the policeman. So if there is no collaboration between these two wings, where there is no civil leadership over the police, Actual leadership should be brought in. That you should have groups which can be attached to each police station, which can also be a civil society monitoring the action. Now, in the case of JB, for 3 days he is kept in the lockup, and there is not even a single person from the village were able to go and see what's happening. Only because the tribals were outside the system. They were excluded. They are not an inclusive society. Whereas in the case of Satankulam, the whole population was in the street protesting for action. Therefore, vigilance of the people, then the civil society monitoring the station, then more advanced technology, and the judiciary becoming more sensitive and realize their role and not to work for cross purposes. These are the things. And finally, the lawyers must have certain amount of social responsibility. They cannot work for with the sole aim that they are only supporting their client and therefore they can do anything to defend him. That should go also.
So, sir, after Jai Bhim was released, there was a lot of talk in Tamil Nadu and across the country about custodial violence. You have been on interview after interview. I remember senior police officers coming and saying, even after Satankulam and the movie release, that we will train police officers to be more sensitive. So, when you read the news about Vignesh's death, when you heard about other custodial murders after, did it disappoint you further?
When Jai Bhim was released, we were also apprehensive that the policemen resent the film because there is a lot of police station torches have been shown graphically, and therefore we thought there will be a whole lot of hostility. On the other hand, I found some of the top officers were very happy because it was ultimately a top officer who works for the unraveling the mystery and then brings out the culprit and even try to give evidence against their own department. So they were very happy because there are good policemen. Even our chief minister said, if there are good policemen and a fighting lawyer and the integrity judge with integrity, these crimes will come down. These are all theoretical assumptions. It is all a hope. But what really happens is that take the case of Jai Bhim, the criminal tribes were denotified and they continue to be a denotified tribe. Now the lower level policemen, all the time when there's a crime, even recently, 3 weeks back in a place in Sithalingam in Kalakurchi district, again 4 Irulas were arrested and kept in the lockup. There's an agitation going on there that how you say all this and see the film, but in real life the opposite is happening. There's a whole lot of agitation is going on. Government has been petitioned, chief minister has been appealed that it is not enough to appreciate the film. In ground reality, it is the other way around, which we have seen even after the film. The Irulas are still continue to be treated as a criminal tribe. Now, when we go to the higher academy, police academy, where there are all India police officers, IPS officers, you sensitize them on these issues, gender issues, tribal issues, scheduled caste issues, all these issues. Everything is fine with them. But down the level, it's a gut police which acts on it. You see the Red Sander, they killed all the loaders who come from Sautarkar district. They went only because of higher wage. They have nothing to do with the smuggling. But 22 people have been killed. The Andhra Pradesh civil liberty groups have taken up the issue. Like that, every time when there is a encounter case, it is some of the civil liberty groups which took up the issue and go to the government and demand. Sometimes they offer the compensation and everybody forgets it. It's not compensation. You can't get back the life. You will have to teach the police different morals, different scruples to adopt in these matters. Even the chief minister, while speaking, said police should not think of doing such things for unraveling a crime. That's a larger issue. But what happens is, can the police get whitewashed because one good police officer comes in a film and unravels it? Or can the lawyers be very happy because one good lawyer fights and brings out the truth? Every lawyer is happy because all other films shown the lawyer in a bad light. This film shows in a good light. Therefore, they are happy. Every section has got some positive aspect in the film, but little realizing the negative aspect of these issues still continues. And everybody is responsible. Why is that the bar does not have a human rights council to defend every victim of human rights violation? Why is that the police officers immediately don't take action? On the other hand, defend the guilty police and try to continue to defend them, saying that this boy was a dangerous boy. These are the issues which we'll have to debate and find a larger answer. Jaibim is only an indicator but does not solve the problem. In fact, there's one dialogue by Surya in that film. He says this judgment is not only for Raja Kandu's death, such death should not happen. Ultimately, the tribals organize themselves into an organization and take to the streets demanding justice. They are not satisfied with one case being decided by the court. And I think the from the exclusiveness to the inclusiveness may bring certain amount of guarantee for social rights of the tribal people.
Justice Chandru, I would now want to move from Tamil Nadu to something which is happening in Kerala. Recently, a few days ago, a woman actor filed a complaint of rape against a actor producer. Now, this actor producer, his name is Vijay Babu. He comes on Facebook Live and he says he's innocent, that he has proof, all that is fine. But he goes ahead and reveals this woman's name, saying that if my name is out there, let her name be there. Now, keeping apart what this man did, there is a lot of debate in society that why should the woman get any secrecy? Why can't her name be out there? So, could you explain why did we decide on 228A? Why is it important to give survivors or victims or complainants their anonymity in India?
Normally, any criminal trial is a open trial. Later, certain events, certain recording of evidence are done in camera. So in camera is only exception. Open trial is a rule. But later, some of the special legislations, it's not only in IPC and CRPC there is such a provision. Like you take JJ Act, you take Family Courts Act, you take POXO Act. There are several other enactments where the revealing of the name of the victim has been kept away from public gaze, and therefore there should not be a printing of or circulating the name. That's how we got the name of Nirbhaya. The Nirbhaya case brought a whole lot of amendments. They even referred to a committee. The committee made some recommendations. And in 2013, the amendments to the criminal laws are being made. But so far as Section 228A is concerned, the original section was brought in 1983. The name of the victim should be kept away, but there are exceptions. It doesn't mean it's always to kept away because there are three exceptions. One, when the police wants to give publicity for directing the crime, they'll have to mention some of the name or photograph, say or identify that photograph somewhere else. If they do it bona fide, there is no offense. If the victim wants her name to come in, she can give a consent for name coming. If the victim is no more, the next kin of the victim can give consent for giving the name. In fact, in Nirbhaya's case, the Nirbhaya's mother wanted to give the name, but the government did not allow the name to be revealed. So we continue to call her Nirbhaya, and there is a fund for Nirbhaya fund, and every government is spending in different ways, and there is no check on how the money is being spent. But one thing is important: the victim and the accused do not stand on the same footing. There's one thing. There is a reason for withholding some name. And the reason seemed to be that a person should not suffer more than what is possible. In the early 90s, we had a case, Chidambaram Padmini's case. She's been raped and her husband was killed in the police station. And it was handed over to CBI. And finally, all the policemen were published. But everybody in this country knows her name. Later, they realized that she has to have a rehabilitation with her life. She has to have a new life. And she cannot go on with this, I won't call it stigma, with this background. People may look down upon her. Therefore, the court itself said, in order to have a better life, the government should give an employment to her. So we are now thinking of victim rehabilitation. Now, in that process, she has been now rehabilitated, given a government job. Now, but because there was no law in 1990, her name is known everywhere. But since there is a law, in Nirbhaya's case, we don't know what is her real name. Therefore, this is something which is more of the nuances. I think the fundamental principle should be that victim and the assailant cannot be kept on the same pedestal. And therefore, if the actor wants to go on social media, give his name, that is his own lookout. Because every accused wants to have some defense and try to defend themselves. Ultimately, the justice will prevail. And see, today you take the case of adultery that's been held to be non a criminal offense anymore. Supreme Court has said it's not a constitutionally not valid. But before that, there was an allegation that the women is not punished, men is punished. In 1963, followed by 1985, Supreme Court said there is a distinction between men being punished and women not being punished. They always said the woman is a victim and the man is not the victim, and therefore the distinction between man and a woman being in the same offense is justiciable. They said even though Article 15.2 talks about non-discrimination based on gender, there are exceptions to that. The exception being when women become more gullible and become defenseless, and therefore they are bound to get involved in such offense. Therefore, the law always treated man and woman in the not same pedestal. The argument that they are equal and therefore they should be equally punished is always rejected by the court. But ultimately, the parliament itself removed that as an offence because they did not consider as a criminal offence. The progress of law may make certain offences which were colonial precedent may be changed to a new democratic setup. They may not want this in the advanced system of society. But to always to say that women are kept differently, being favored is not a correct thing. Statistics have shown that women have been the victim to many of the circumstances. Maybe there are exceptions, but the exceptions do not make the rule.
I want to now move to politics, sir, and I know that you have very strong opinions on this. Recently, Tamil Nadu Chief Minister M.K. Stalin said that the governor should do the job of the postman and forward the bill on the NEET ban to the president. We have seen a lot of friction between the current Tamil Nadu government and the governor, and previous governments and governors too. And we are seeing that in Kerala also. But do you think that in many cases, the governor's office is eroding the very spirit of federalism?
It was perhaps the first time in 1967 the Congress party lost its monolith of being a single, only ruling party in India. In 8 states, they lost the elections, and opposition coalition came to power in 67 for the first time. First time, they also realized they can be a opposition party in several states, very important states like Tamil Nadu. Then this game started that people who are discredited in politics are offered with gubernatorial posts, governor posts in some state. People who want to remove faction in a state are sent to one group is sent as a governor, giving them some kind of a status. Secondly, an elected government is trying to be made destabilized by actions of the governor. Now, no doubt, Article 161 talks about there shall be a governor. But the next sentence says, who will be aided and advised by a council of ministers headed by a chief minister. Now, whether he is bound by the advice or not, he may or he shall. There is a difference because in president he shall, in governor he may. But the Supreme Court has consistently said the word may does not mean that he has a ultimate discretion in every matter. Ultimately, it's an elected government. It's a popular government which can have a decision-making process. And the governor is merely a sage who merely advises and try to keep the state in a right path. Now, when he wants to give a consent or assent to a bill or amnesty order to be passed, he is bound by the advice of the governor. Now, this debate started in Tamil Nadu. In fact, when Nalini and 3 others were approached the governor for a mercy petition in 1998, first the governor sat over it, and then the lady governor, who herself was a Supreme Court judge, dismissed the petition without the advice of the cabinet. Then the Nalini and others went to the High Court. 1999, the Madras High Court came down heavily upon the governor office, saying that knowing the law, how do you commit this mistake? The law is very clear because it says that the governor cannot act without the cabinet advice. Now, when that decision came, Kalaignar was a chief minister, finally gave reprieve to Nalini and rejected the case of 3 others. And the 3 others went to Supreme Court. Their grievance was slightly much more severe because two presidents, refused to deal with mercy petitions. They just kept it pending. The result was these people continued to be in a death row, which is not an expected punishment. They can be given life sentence, but not a death row forever. Every day when the morning comes, they will not know whether they are going to live or not. Finally, the Supreme Court passed a very important order. They said, we have seen the record that to take a decision, does it take several years, especially in a case of death penalty. Now, Supreme Court said, since the president did not pass orders for all these years, we will exercise our extraordinary power under Article 142 and reduce the death sentence into life sentence. This was done by a judicial fiat. They also gave a direction to the president that in such matters you got to take decision within a reasonable time. Otherwise, we'll fix time for you. Therefore, an area where which has been undefined, unclear, or not yet defined, the court has stepped in. Recently, I had an occasion to write an article for an English newspaper. I said, in the case of Rajiv Gandhi murders, the state government and central government are playing football. Maybe nobody wants to take a decision, and therefore it's high time the court exercise the power and take a decision. This is a question they asked yesterday, that if you don't say anything, we'll pass orders. Now, in a sensitive matter, when a constitutional functionary is deter or little lazy or little hesitant, do you think that every time court should take action on these matters? This is a question. All the time you say the court is not a third chamber. The court is only to review. Now you don't take a decision and you make somebody else take decision, because the issue involved is the liberty of a citizen. And the liberty has to be protected because Article 21 protects liberty. In Tamil Nadu, we find a new game because the BJP has now chosen Tamil Nadu, like they've chosen Kerala, and their experimentary laboratory is Karnataka. And therefore, these southern states, now which is on the radar of the central ruling party, so in each state they are adopting different methods, knowing fully that Tamil Nadu people will not succumb to their tactics. They are using governor who is not an elected person, and in this case they even appoint the police officer as a governor. And then what he does is just sits over the paper, no decision. Procrastination is not contemplated in the constitution. Either you say yes or no. The power to give assent to a bill is very limited, because ultimately every bill in this country, unlike in Sri Lanka, where the bill goes to the court first, and once court rules, nobody else can challenge. But in our country, in every high court, we can keep on challenging. For every small court, we can keep on challenging. And therefore, the governor has very little direct vote. When somebody cornered him, he said, I'm consulting some legal lawyers. Every lawyer has to give an opinion, especially when the governor asks, he has to give an opinion immediately, and how long it will take, and what kind of opinion. As if there are no precedents before. The precedents were there in 1999 in Nalini case, that you are bound to accept the cabinet. Like that, when the assent comes, all that he has to see whether it comes within the power of the governor or it has to go to the president. There are only two options. In fact, when the chief minister said, I am not a postman, but in a case of this nature, the governor is a postman only. I think more than that. He does not have any more power than a postman does. Somebody ridiculed when I said like that, saying that, how can you say that? When a postman has to deliver a letter, he does not deliver. There are some incidents, extreme incident where postman threw off everything in a local pond. The department has to take action. Therefore, the governor action can be taken against the governor for disregarding the constitutional responsibility vested on him. But he does not send. He sends the bill back to the legislature. Again, it comes back. Now, what is the other option open to him? Send it to the president. If you think it requires a presidential approval, send it to him. This exercise could have been done not today, but 4 months back. Why delay? Therefore, they're very clear that he has been sent to play a ball game, sent to play a low-level politics of antagonizing an elected state government and trying to irritate people who are expecting something. Suppose tomorrow the president does not give assent or the governor rejects it. There are courts to take care of it. It doesn't mean that you should decide what is the law. It is for the court to decide. Under the constitutional scheme of things, even if you decide something according to you is legal, the court can say the opposite also, because the court, it is ultimately the repository of a judicial review rests with the court, not with the governor. If you understand this, then certainly you would not have been playing such cheap tactics of withholding the bill eternally. Now, after so much noise, one bill is sent there. The accused in Rajiv Gandhi murder case. Last week you heard the Supreme Court saying, what is the governor thinks? Every case he has to send it to a president to get his opinion. Then why is he a governor? Now, should we invite such criticism from the highest court of this land? If for that criticism, he should resign and go away. He should not stay there. A gubernatorial post is not for celebrating party and then visiting places or visiting some spiritual centers. That is not the issue. More than that, it is a legal constitutional matter where an elected house sends a bill for assent. You will give the assent or refuse the assent. People will take care of it. But sitting over it or postponing it is amounting to killing the bill, killing the initiative, killing democracy. I think that's not contemplated. This is what they do in every matter. And recently you find in the education matters where Vice Chancellor appointment, the law says that three names will be sent. Vice Chancellor appointment, he becomes only a Chancellor. The appointments are issued in your name. Even government appointments are issued in the name of the governor only, by the order of the governor. It doesn't mean governor signs. It is only sent for his information. It is only the government which decides. Now somehow they interpreted like the UK model. The Chancellor is a visitor and therefore he has some power. His power as a visitor is only a supervisory power, not running the establishment. The running the establishment is given to the syndicate, and the syndicate elects a representative. Governor nominee is there, state government nominee is there, and then they sit over, invite application, and then shortlist and then send three names. You reject all the three names. Okay, you call for a new name, but then you give extension to the existing vice chancellor. You reject every name, not one or two. Even 100 names that come, you reject. Then where do you get this wisdom? Ultimately, you are guided by the constitution. Without the constitution, where are you as a governor? Now, this is the question which people have to ask. This happens in Kerala, this happens in Tamil Nadu, and then, several other things are happening where governor is sitting quiet and not taking action, like in Karnataka.
There's a lot of conflict in Telangana also.
Yeah, that is true. Yeah. Everywhere there is a grievance. It doesn't mean the peninsular India are up against the government. In fact, once upon a time, Dr. Annadurai, the first chief minister of Tamil Nadu from DMK side, he said, when the goat need not have a beard, why should the state have a beard like a governor? Therefore, that's a very valid question. They did not make it as a rhetoric. They appointed Rajamanar Commission, who was the first chief justice for 15 years in Madras. He gave a report that the governor post, though may be constitutionally provided, the state cannot be ignored in selecting a governor. In fact, the demand from the southern state that they should have a say in the matter of selecting the governor. Like a vice chancellor appointment, let the central government send three names, let the state government approve the name. Then the issue will be different. Now, then it will be more democratic. There will be somebody who will be responsible to the constitution. Now it looks like Home Ministry is playing a game. That is why you will find in Kashmir from a statehood to union territory, which means it becomes extension of the Home Ministry. Same thing happens in Puducherry. They nominate MLAs. So they try to control the very government itself. But in a full-fledged state, such things can never happen. But what happens is the Home Ministry treats the union territory and the full-fledged state in the same way because their mindset is different, their objective is different, their game plan is different, where an elected government want to replace by this confusion. But in a center, which is supposed to be a federal, when people objected, union of states, when they said, it is a union of state, but when they said, your only job is to guide and advise and help state government so that it will run by the elected representative of the people. On the other hand, you specialize in destabilizing the government. It is not going good to anybody because you can't have war within your own country. You may have war in the border, but not in the inside the country. That's what happens today. Even a smallest petty politician, what Amit Shah calls Tukre gang, they are trying to create problems with the help of the center, with the help of the blessings of the center.
So you have called the governor, especially the governors in many states, the union government's plan to really derail state governments. But you also said that why do governors take decisions so late? Why do presidents sit on a bill? Why do presidents sit on bills? And the point that you said is eventually the courts will decide. But my question back to you is that in present India, are you saying that people can still keep their trust in judiciary? Because many observations made lately, even a few judgments, have eroded confidence to a large extent, even in the judiciary.
I am not saying that for every answer will come from judiciary. I'm pained to say that judiciary did not measure to our expectation, and many of the fundamental questions, the judiciary is dragging its feet and not deciding. Cases like now they fixed the date for Article 370. Why should they delay for 3 years when entire balkanization or dividing the state as complete, and then you start making a review. The review should come in advance, not like a postmortem, like Citizenship Amendment Act, like a UPA. 3 years, the people are languishing in jail, and you don't want to take up those cases. But we find the Chief Justice going all around the India, giving press conference, press statements. People made to believe there's a very progressive Chief Justice we have in India because he comments on every issue that is possible, and people also start having faith because of the breaking news that is given by him. On the other hand, there is 72,000 cases pending with the Supreme Court. Not every case may be important, but there are very many important cases touching the lives of people, touching the very sensitive parts of the Indian Constitution. Why no benches are being constituted for hearing these cases? Therefore, the delay by the judiciary, sometimes they may say it's inevitable. Sometimes if the delay is attributed to say deliberate delay, then it becomes a questionable action by the judiciary. When I went to Andhra Pradesh, I made a statement that the Andhra Pradesh judiciary is functioning very way in which the people slowly start thinking, where do they go? Now, I gave three instances. Even I wrote an article that in one case, the Advocate General did not file a statement in time. Normally, they impose penalty for delay in filing returns. Now, this bench passes an order. If by tomorrow the returns are not filed, we'll advise the president to impose president rule. Does it open to the High Court to say like that? A matter which comes within a habeas corpus case. Within the High Court has to decide or dismiss the case or go again, made a stricture against the government. But a judge's right in the order, it's not a oral statement. In the order, they said by tomorrow, if returns are not filed, we will recommend to the president for a president rule. FIRs are quashed. Subcommittee recommendations of the cabinet quashed. No inquiry. Now, when I said that it is not ordinary people who need justice, even the chief minister sometimes require justice. For example, the Amaravati land acquisition case. The bill was passed to have three capitals. Now that matter was challenged in a public interest litigation. Courts are hearing the case. There is no bar for the government to withdraw the law. And the legislature permitted withdrawal of the law. The law is withdrawn. Now, when there is no case before you, how do you deliver a judgment? Saying the law is bad. In fact, the Advocate General told the court that the law has been withdrawn. There is nothing for you to judicially review. Do you still pronounce matters which are not before you? Now they pronounce matters. Now, when I said all this, no, take contempt action. Contempt cannot be used to silence strong opinions against the functioning of the judiciary. I find that whenever we say that matter has to go to court because under the constitution, it is only the court which can judicially review every executive action. And when the court do not review, we start also slowly losing hope, which is the last hope of any citizen. And that last resort do not give us enough the assurance. I think we'll also slowly lose hope and start demanding some other change in the very setup itself. And I'm not saying that every issue can be solved by court. I know I can give you 101 incident where we pronounce orders and never implemented. The limitations of the judiciary is also still there. They may only at the maximum pronounce the legality of a law. But after pronouncing, if no action is taken, what the court can do? Issue contempt against one person. Now they issued contempt against Kalyan Singh, the then Chief Minister of Uttar Pradesh, punished him for 1 day till the raising of the court for contempt of court, having allowed the Babri Masjid to be removed. Now that man now posthumously given Padma Shri Award. Therefore, where do you go from rule of law and to some other areas where you reward people who work against the judiciary, work against the constitution, work against the established principle of law. So therefore, we also have parallel forces which try to run this country in the name of several other their own fancy ideas. Therefore, today the question comes, where does this country is being run? Is it run from Delhi or from Nagpur? Now that is the question. That will finally decide what is the role of judiciary in this country.
So I just wanted to have a freewheeling chat with you, Justice Chandru, about various things. I want to end this discussion. I was listening to a speech that you made recently where a veteran journalist BRP Bhaskar was being felicitated. You said in that ceremony that democracy will reject the politics of bulldozers. Is that your reading? Because election after election, we see that the BJP's arithmetics, where they talk about development, nationalism, Hindi, Hindu, Hindutva, these combinations are working. But what made you say this?
That we in 1976 consciously amended the preamble to the constitution to make India as a sovereign, democratic, socialist, secular republic. Now, the word socialism and secularism has certain meaning because in Keshavananda Bharati, Supreme Court said preamble is also basic structure of the constitution. I do not think that we can allow anybody to be deviated. Even today, you will find in BJP constitution, it says that they believe in socialism and secularism. Maybe it's something to be laughed, but no party in India can survive without their party constitution declaring their allegiance and their loyalty to socialism and secularism. If that is taken as a fundamental principle, any move which will destroy that should be condemned. Whether it's a case of hijab or a hilal or azan, whether roti, kapada, makan, what do you want to give? You are now using certain techniques in areas which have never been known earlier. Today, Karnataka is certainly being used as a laboratory for certain Hindutva experiments, which will only divide people. Which will divide people in such a way that for last 72 years we kept this country together, and that is because of this constitution and its underlying principle. Every subcontinent states in this subcontinent have gone in a different direction, but we try to hold India together because of its multifaceted, multilingual, multicultural background. Now, if anybody speaks on this, somebody says one nation, I agree, but one language, one food, one cloth. I don't think that any such person has got a right to say that. This is what I said in Bhaskar's book release and honoring him, one of the finest writer of Kerala and finest writer. I would want to say this, that if you want to keep right of expression, which has got a many facet, there is nobody can enter into that area and say what they think is a universal idea for this country. This is what I was saying, that you can't have a bulldozer democracy. You may not give houses to anybody, though you may promise in your election manifesto, you may want to give houses for the poor, but then we do not want any houses from you. But we don't want bulldozers also from you to demolish our own initiative. Now, what happens is the bulldozer has become a symbol that where everything has been built has been destroyed in 1 minute. And the destruction is not universal, destruction is selective. Then the motives are questionable. Fortunately, the Supreme Court has granted stay, but I do not know how long it will continue. But it is only the united voice of the people which can stop this bulldozer democracy.
It's only the united voice of the people that can stop the bulldozers. Thank you very much, Justice Chandru, for sharing your thoughts on a wide range of subjects. I hope to come back to you soon. Actually, not hope to come back to you soon also, because which means there are a lot of controversies to speak about. Thank you very much for joining us at the News Minute.
Thank you.